Hello students, how are you? I hope you are doing good. So in the previous session we have talked about disadvantages of company, and before that we had discussed about the advantages of company. Okay, so these are very important questions from exam point of view. So let's proceed further and let's get started with the new topic today. The topic name is, so today we are going to talk about types of companies. So today's topic would be types of companies. Okay, so today I'm going to talk about the various types of companies. Okay, how it gets established, then what the provisions relating to such type of companies in the company law, Companies Act 2013, and so on. So first let me just put down the types of companies. Okay, and then we'll start discussing about the same. So how many types of companies are there? So we can classify companies from the beginning. Okay, like we used to have, because we were ruled by the Britishers. In that time we used to have some kind of companies, and that is the reason I can put that chartered company. Okay, so chartered company is one of the type of company. Okay, then we have statutory company. Then we have government company. Government company. Okay, we can have on the basis of liability, limited by shares. Then on the basis of liability we can have limited by guarantee. Then unlimited company. Okay. We can have private limited company. We can have public limited company. And small company. We can have one person company. Which is also popularly known as OPC. So I'll just use the short form over here. We can have foreign company. Holding company. Subsidiary company. And last category is associate company. There is one more category. What I'll do, I'll put it in the next page, no problem, for your convenience. So we can have associate company. And then we can have company charitable purpose, which is also popularly known as Section 8 company. Okay, so many types of companies are there. We are going to study one by one, okay, with the help of examples. So what exactly do you understand by this word chartered company? Okay, my first question to you. So chartered company, okay, as we all know, it is basically, okay, created by some charter. Okay, so I have given the example of the Britishers. So Britishers, when they came in India, they had come in India, okay, with some business motive. Okay, they wanted to do some trade in on Indian territory, and accordingly they established a company in the name of the charter. Okay, so that was one of the example we can take, that is East India Company. East India Company. See, we are talking about the general question of types or classification or kinds of company, which may be asked like that also. Okay, so in the classification you can definitely give the companies, okay, which are not registered under the Companies Act. So all these companies are not going to be registered under the Companies Act. Let me just clear that for the first particular point. Okay, so charter company used to get registered under a specific charter, okay, of the Crown of the Britain, okay, and as per that only they used to get their existence. But for your kind information, students, such companies are not in existence in India right now. But yes, one of the type of company you can always say that, okay, chartered company. So let's talk about now the statutory company. What is mean by statutory company? So these first 2 points, okay, the chartered company and the statutory companies are not registered. They do not get their registration through Companies Act 2013 or Erstwhile Companies Act. So statutory, when I say statutory company, what does it mean? Statute. Statute means a specific act. So such type of companies get their existence through their own statute. So can you name any particular company, okay, which has got its existence through its own statute? The name of the company you can say RBI, there is SEBI, LIC. Okay, I know in LIC now the talk is going on that it will be disinvestment and everything will take place, but still it is, we can call it as statutory company. So statutory company gets its existence, gets registered under specific statute, specific act, we can say. So specific act, it may be a act of central government or state government. Even the state government may have some kind of statutory companies. So what is one more thing over here? So who is the shareholder of this company? So 100% shares, okay, 100% shares are held by central government or state government, either jointly or severally. So they can have their own setup, okay, or they can have the joint venture also in the central or state government. But you and me as a shareholder, we cannot become the shareholder of such companies. So to name to know about these companies, we can take name of RBI, we can give example of the LIC, okay, SEBI. So here these are some of the examples, okay. Ideally these are not called as companies, but these are the statutory companies, okay. So no provision of the Companies Act 2013, okay, will be applicable to all these companies. So how their business is going to be governed, okay. So the regulations and what is the composition, what are the rules and regulations. So they will have their own statutes, and as per the statute they can some frame rules and everything. So we need to refer to the specific act for that particular purpose. Just to give you example, RBI Act 1934 is there to regulate the business of RBI. Under RBI, there is a composition given, how the governor should be appointed, deputy governor, then the central board of directors under the RBI. There is a hierarchy given, okay, how the offices can be set up, branch offices can be set up, and so on. general manager, chief general manager, all those provisions are given. So these are the statutory companies. So if you are dealing with any statutory company, no provision of the Companies Act is going to be applicable. You will have to refer to the specific act only. Let's talk about government company. So now we are moving to the part of the, you can say, Companies Act. Okay, government company. So what makes it different from the statutory company? Okay, so under section 245, it says that government company as a company in which not less than 50% of the shares paid up capital is held by central government or by any state government or governments, or partly by central government or partly by one or more state governments. So what do you understand? There is one more clause given over here, given under this particular provision. So if a subsidiary of a government company is there, it is also considered to be as government company. So in government company, what happens? Government company में क्या होता है? Okay, more than 51%. So you can say more than 50%. So we are just taking more than 50% ही लिखते चलो. More than 50%, more than 50% shares, okay, are held by central government or state government. I am just using the short form for your understanding. Central government or state government. Okay, so you and me become the shareholders in the government companies? Answer is yes. Okay, so more than 51%, what does it mean? The main control will be in the hands of the government only. Okay, main control will be in the hands of the government only. And there are some specific or the prescribed government companies where the audit will be taken care by the Comptroller and Auditor General of India. Then there are certain provisions relating to the filing of the annual returns. Okay, the separate provisions can be made for such kind of government companies. So to name few companies, we can take name of ONGC, then NTPC. These are some of the kinds of government companies. Okay, where the shareholder can also become, okay, the outsider can also become the shareholder, okay, in such government companies. So we have talked about, okay, so far, 3 types of companies. The first one was chartered company, and then we have talked about statutory and government. So did you get the difference between these two, statutory company and government company? So what is the main different point? Okay, here 100%. Okay, 100%. Okay, the shareholding is with the government. Whereas in case of the government company, it is more than 50%. So you can say one sentence, all statutory companies are government companies, but all government companies are not statutory companies. Because, okay, government company need not be a statutory, because and the main point of difference is government companies business is regulated by Companies Act. The registration and everything will be taken care by Companies Act 2013, and that is not the case with the statutory company, because statutory company is having its own statute, having its own act, okay, which will be regulated by it. So let's talk about the next set of companies. Okay, so I'm going to say like, okay, this can be on the basis of liability. Okay, the next set of 3 companies we will study together on the basis of liability. So liability can be on the basis of share, on the basis of guarantee, or on the basis of unlimited liability. Normally, what is the feature, very important feature we have studied? Okay, the company's liability is limited. And that is the reason the company form of business is so popular compared to the partnership form. Because in partnership, you get the unlimited liability. But as you can see on the blackboard, okay, it is mentioned, unlimited liability is also mentioned. So can a company be formed with the unlimited liability? Okay, so let's get started and let's try to understand. So what is meant by, okay, limited by share? So company limited by share may be defined as a registered company. It can be either public or private limited company, okay, having the liability of its members restricted, okay, or you can say limited by the memorandum of association of the company to the extent of their shareholding. Okay, so liability कहाँ तक लिमिट रहता है? To the extent of unpaid shares. Students, when I have taught you the topic limited liability under the features of the company, I had given you one example, okay, where the company is there. Let me just give you one example. So let's try to understand companies on the basis of liability. Okay. There can be three different sets. First is limited by shares, limited by guarantee, and here unlimited. Okay. So what happens over here? Limited by shares. When I say limited by shares, so if A in under A, B, C private limited, I will just revise that example. Okay, let's assume that there are 3 shareholders, and under 3 shareholders मान के चलते चलो इधर 50% है, इधर है 25% and 25%. Okay, so these 2 shareholders have already paid their amount, but out of 50%, okay, let's assume that, okay, the capital of the company is 1 lakh rupees. Okay, when I say 1 lakh rupees is the capital, means it becomes 50,000, 25,000, 25,000. Now out of this 50,000 rupees, let's assume that A has only paid 25,000 as application money. So what is the unpaid amount? Unpaid amount is, okay, 25,000. So what will be the liability of the shareholder A? So can there be any kind of liability on B and C? So in case of limited by shares, okay, where exactly you mention that the company's liability is limited by the shares, it is mentioned under the memorandum of association of the company. Okay, there is a clause in the memorandum of association of the company which is known as liability clause. Okay, I'm going to talk about this, okay, when I am going to teach you, okay, this particular topic in detail, the memorandum of association. So under the liability clause, okay, the company has to mention, okay, that the company's liability is limited by share, by guarantee, or whether it is the kind of unlimited company. Okay, and if it is mentioned that it is limited by the shares, then the liability of the members will be limited to the unpaid part of the nominal share. So if he has not paid 25,000 rupees, then only the unpaid part is 25,000 rupees, and that would be the liability. Okay, so when the liability will occur, so basically, okay, liability will occur when the company will go for some kind of winding up. Okay, so if the unpaid part is there, then only the liability will occur. So it is not like that partnership firm where the personal assets of the members will be held liable. So if the shares are fully paid, so like in our case, B and C, they have already fully paid. Okay, there is a fully paid of shares, there are fully paid of shares, so their liability will be nil in that particular case. Only A will be liable for 25,000 of rupees. That is the unpaid part of the capital. So let's assume that, okay, let's talk about limited by guarantee. Okay, so the liability of the members limited by guarantee can be decided under memorandum to such an amount as the members may respectively undertake. Okay, as the members may respectively undertake. So जितना अमाउंट उन्होंने अंडरटेक किया है कि हाँ हम लोग गारंटी दे रहे हैं कि इतने अमाउंट का हम लोग पेमेंट देंगे, irrespective what is our shareholding, okay, then that will become limited by guarantee. Okay, so they will undertake this particular amount where they will undertake to pay this particular amount under the memorandum, again under the liability clause, to contribute to the assets of the company in the event of being wound up. जब कंपनी वाइंड अप के लिए जाएगा तो बोलेंगे कि ओके, नो मैटर व्हाट इज अवर शेयर होल्डिंग, वी आर गिविंग और अंडरटेकिंग दिस पर्टिकुलर liability. So liability of the member is to pay the guarantee amount arises only when the company will go for liquidation and not before that. That you need to remember. So which are the types of organization which go for the guarantee companies, like the clubs, you can say trade association, or the societies promoting different objects may go for such type of companies. Okay, not the companies, basically this is not the restriction, but the companies which are going for some business activity and profit motive. Unlimited company, very unpopular in India. Okay, I would say unpopular in India. Why this is unpopular? Okay, because if why person is coming to the company form of business, first try to understand that, because the main feature is he does not want to take that particular liability on him, that is unlimited liability. So what is meant by unlimited liability? In case of unlimited liability, person will be responsible for his personal assets will be responsible, because there is no liability, no upper liability, no definite liability. But what exactly makes it different from the partnership form of business? In case of unlimited liability companies, again the liability will occur in case of winding up only. But in partnership, it may occur in between as well. That is the main point of difference between unlimited liability companies and partnership firm. So there is no maximum liability, okay, but in case of the winding up, it may stretch up to the full extent of their properties to meet the obligations of the company. So whatever may be the obligation in future, when the company is going for the winding up, members will have to fulfill it. But as I told you, this is very unpopular form of entity in India. Okay, I hope you understood these particular points. Let me just go back to our topic. Okay, so far we have covered charter companies, statutory company, and government company. So limited liability, that is limited by shares, limited by guarantee. So you can say these are limited liabilities. Limited liabilities, and this is unlimited. Okay, so these three we have already completed. So let's move on to the next one. Private limited company. Okay, private limited company. So which is defined under section 2, subsection 68. Okay. Students, you may just get confused. Don't get confused, because all these companies are not defined at one particular page. Okay, these are the scattered provisions defined under various definitions. Okay, so limited liability is on the limited, unlimited liability is on the basis of liability. So private limited company may be limited or unlimited, like that. Okay, so don't get confused. So this is a definition which is defined under section 2, subsection 68 of the Companies Act. This says that it means a company having a minimum paid up share capital as may be prescribed. Minimum paid up share capital as may be prescribed and which by its article restricts the right to transfer its shares. So minimum pair of share capital can be described by the government, okay, in Ministry of Corporate Affairs through rules. So which by its articles से क्या कर रहा है, कुछ restriction डाल रहा है इस कंपनी पे. So first restriction, restrict the right to transfer its shares. Private company may be restricted to transfer the shares, except in the case of one person company limits the number of its members to 200, and persons who are in employment of the company, okay, provided that whether two or more persons hold one or more shares in the company jointly, they shall for the purpose of this be treated as a single shareholder. That is different part. Prohibits any invitation to the public. Okay, so we need to understand these three different points. So when we say private limited company, okay, when we say private limited company, so there are three categories you need to understand. Three important points. So what is the first important point? Okay, what is the first important point? So first important point is it may restrict the right to transfer the shares. Okay. Maximum number of members, 200. And third, prohibits any invitation to public. Okay, these 3 points are important. The first point, it may restrict the shares. Okay, जैसे कि मान के चलते कि A, B, C प्राइवेट लिमिटेड है, okay, जिसके है 3 शेयर होल्डर A, B, C. Now C wants to transfer his shares to D. So what restriction can be put by articles? ये restriction कहाँ से डाला जाएगा? Articles से डाला जाएगा. Articles of association. So in articles of association, such clause can be there that without asking, okay, or without offering the shares to A and B, C cannot transfer to the outsider. So first C has to give an opportunity to A and B, and if they do not or they don't go for that opportunity, then C can transfer the shares to D. So this is somewhere similar to the partnership form of business, where in partnership form of business, without taking consent at all, you cannot introduce new partner. But here, if they do not go for the offer, then definitely he has option to transfer his shares. So such type of restriction can be laid down under partnership, under private limited companies through articles. How many members can be there? 200. Students, earlier limit was 50. Earlier limit was 50. So don't get confused. Okay, पहला लिमिट 50 था तो ओल्ड बुक में अभी भी ये रहेगा, लेकिन अभी ये एप्लीकेबल नहीं है. दिस इज एप्लीकेबल. So maximum can be 50. See, one person company is a kind of private limited company only. When we say private means what? Private funds are involved. Okay, but except in case of one person company, you can have maximum 200 members, because one person company can only have one member at a time. Third point is basically it prohibits the invitation to the public. Okay, so invitation to the public means what? It cannot invite public to invest funds or contribute the capital. Why? Because it is not allowed for private limited company. So only public limited companies can do so, or they can invite, okay, public for the capital contribution. Okay, so it is not allowed, prohibits any invitation to the public. So these are the main differences. Again, there are some different points whenever we will study the difference between private limited and public limited in detail. We are going to have that particular topic. Okay, private limited, public limited, and that time, okay, we are going to have such discussion. So till that time, okay, we will not discuss about this invitation, prospectus and all those provisions. Okay. So whether you have understood this particular provision? Okay. let's go back. So public limited we have completed, private limited we have completed. Public limited company, which is defined under section 2 subsection 71. We says that public limited company means a company which is not a private company and has minimum paid up share capital as may be prescribed. Okay, so provided that a company which is a subsidiary of a company not being a private company shall be deemed to be public limited company for the purposes of the Act, even where such subsidiary company continues to be a public limited company in its articles. What does it mean? Okay, let's try to understand. So we have understood this. Now we'll talk about public limited company. So public limited company क्या है? Mainly which is not private limited company. Okay, so to understand this, you need to better understand private limited company, then only you can very well understand public limited company. So my question to you is whether public limited company can issue the shares to the public. Yes, the word itself says that it is a public limited company and not private funds are involved. So it can issue the securities to the public as well through invitation. So there are some provisions, we will talk about that. One more criteria is given. Of course, the minimum paid up criteria which is applicable to the private limited, here also it is applicable. The ministry will decide from time to time what should be the minimum paid up criteria. But now, in case the company is having the subsidiary, if public limited company is having subsidiary which is private limited, such company shall be deemed to be public company. I am using the word public company, it is public limited, public company. Okay, so what does it mean? Okay, so what is given over here? Okay, if the public limited company is having subsidiary which is a private limited, such company shall be deemed to be a public limited. Means, let's assume that over here ABC private limited, public limited is having a subsidiary, okay, XYZ private limited. So when the incorporation was happened for XYZ private limited, okay, for incorporation purpose it is a private limited company, because under MOA it will be considered as private limited only for all the purposes, but it shall be considered, because if this is the holding company, okay, I am aware you are not aware about this, what is holding and subsidiary. I am going to cover that point as well. Okay, then in that case, just for the time being, okay, understand that, okay, this is holding and this is subsidiary. Then for all the purposes, okay, it shall be considered as public limited company only. So for all the purposes, it shall be deemed to be a public limited company. Okay, though on the paper it is private limited company. So once you will understand the concept holding and subsidiary, then definitely you please go and revisit this particular part. You will understand in a better way. So students, we have covered public limited as well. Let's talk about small company, which is defined under section 2 subsection 85. See, small company is a type of private limited company only, okay, but there has been a different classification made under 2013 Act, which was not there in earlier law. in 1956 Act. Okay, and so small companies, so companies which are private companies but having the less paid up capital or less turnover should be considered as the small company. So why these are the small companies? Because they are falling under that particular criteria, and the second important thing is they will get some kind of exemption. The additional exemptions will be given to the small companies. Okay, so let's talk about that. So small company definition says that it means a company other than a public company. Of course, it cannot be a public company. It has to be a private company only. Okay. First point, where the paid up share capital of such company does not exceed 50 lakhs. Okay. So it is, okay, you can say below 50 lakhs. What is paid up capital? And second criteria, this is my first criteria, and second criteria, turnover of which as per the last profit and loss account does not exceed 2 crores. This is my turnover criteria. So if my, okay, this is or condition, okay, if in my case, okay, if my paid up capital is below 50 lakhs or as may be prescribed, means the government can make the modification in such criterias, or 2 crores turnover. So either of the condition is meeting, okay, so in that case my private limited company will be called as small company. Okay, provided that nothing in this section apply to holding company or small subsidiary company, company registered under section 8 or under any special act. Okay, so basically these companies will enjoy certain benefits, like there are some benefits given under the general meetings. Okay, there are benefits given for the board meetings and all that. Okay, we'll talk in detail later on. One person company. Okay, let's talk about now OPC. OPC, one person company. The name itself says that, okay, how many members can be there? Only one member can be there. Okay, not more than that. Now, okay, why this company form of business? See, earlier this particular form of business was not there in India. Such kind of form of business was never recognized in India. But later on, okay, government thought that, okay, let's have this form of entity, okay, just to attract the sole proprietor. So there are some provisions relating to the one person company. Let's try to understand one by one. So when I say OPC, I will use the short form. Okay, OPC. क्या डिटेल में प्रोविजंस रहेंगे? Okay, so first try to understand. It means a company which has only one member. तो क्या क्या रहने वाले हैं इसमें provisions? पहला provision, only one member. You can only have one member, not more than that. Okay, so one member रहेगा तो क्या रहेगा उसमें, कौन की responsibility लेगा? And that is the reason there is a provision. The memorandum of this company should provide a nominee name. Okay, so nominee रहेगा एक, जिसको हम लोग कहेंगे कि why his nomination is required, because if anything will go wrong or if anything will happen to this particular person, then who should be responsible? Okay, so a nominee is required. Nominee is required. So when the nominee is required, see, without taking his consent, can you force anyone? No. So in that case, his consent will also be required. Okay, consent has to be obtained from such nominee. Okay, so with the prior consent only he can become. And of course, when he will be held liable in the case of death only, or the death of the one member, okay, which is given over here. So only try to understand, in other forms of entity, the artificial entities also can become the shareholder. But in such kind of entity, only individual can become the shareholder. He should be natural person. He should be natural person. He or she should be natural person. So individual. We can say individual. Okay. And when I say individual, again he should be resident of India. Resident of India means what? He should have stayed for more than 182 days in the last preceding year. Okay, so these are the some of the additional qualifications. Okay, no minor shall become the member. No minor can become. See, can minor become the shareholder? Yes, but in this case, no minor can become member or shareholder. What? In such company can't be converted into Section 8 company. So Section 8 company is basically for the charitable purpose. OPC cannot do business of non-banking financial investment. I would say non-banking financial investment. So they have been restricted from doing such business. So you need to refer to these points. So only one member at a time, okay, not more than that. एक nominee चाहिए, then he should be a natural person only, who should have been resident of India, no minor, then cannot be converted into Section 8 company which is for the charitable purpose, and it cannot do the business of non-banking finance investments. Okay, so these points you need to remember. चलो आगे बढ़ते हैं हम लोग. Foreign company. What can be a foreign company? Okay, पहले तो definition जान लेते हैं. It means any company or body corporate. Okay, I forgot to mention the section 2 subsection 42. Okay, it means any company or body corporate incorporated outside India which has a place of business in India. It is a company which is not incorporated as per Indian laws, but which is having a place of business in India. So such type of companies will be called as foreign company. So क्या pointers है इस पे? So company is incorporated outside India. Company is incorporated outside India, but conducts any business activity in India. Okay, तो ऐसी कंपनी जिसका इनकॉर्पोरेशन आउटसाइड इंडिया में हुआ है, ओके, बट वो कंडक्ट कौन सा बिजनेस कहाँ कर रही है? इंडिया में कर रही है. सो कैन यू नेम फ्यू एंटिटीज लाइक दिस? ओके, वी कैन टेक एग्जांपल ऑफ द Amazon, we can take example of Unilever. Okay, of course Unilever is having the subsidiary in India, but if Unilever is setting up any kind of branch office in India or conducting any business activity directly in India, then it will be called as foreign company. Now the question will arise, once it is registered under the foreign law, so whether that company has to comply with Companies Act 2013 or not. So to answer this question, answer is yes, and that is the reason, okay, the foreign company has been defined under section 2 subsection 42. So there will be a different set of compliances given under Companies Act 2013. Let's talk about holding and subsidiary company together. Holding and subsidiary company together. Okay, so what I'll do, holding company which is defined under section 2 subsection 46, it is defined under section 2 subsection 67. Okay, so holding company and a subsidiary company. Okay, let's try to understand in detail what can be the holding company and what can be a subsidiary company. Okay, I'm going to teach you these definitions. Holdings together, subsidiary companies. Okay, holding and subsidiary companies. Okay, what can be holding company and subsidiary company? So here I will put the name holding company. Here I will put the name subsidiary company. Okay. So holding company says that in relation to one or more other companies means a company of which such companies are subsidiary companies. So in order to understand this holding company, you need to first understand subsidiary company. So let's first understand subsidiary company. The definition said that in relation to the other company, okay, that is to say subsidiary company means a company in which the holding company controls the composition of board of directors. So subsidiary क्या है? पहला point इसमें दिया है controls the composition of board of directors. और second point क्या है? Exercises of control more than 1/2 of the total share capital. Controls. Okay, this is the or condition, don't forget. Controls more than 1/2 of the total share capital. 1/2 of the total share capital. Okay, so it can be controlled by individually, independently, or you can say combining with the other companies. Okay, so jointly. So if it is controlling, so I'm just giving you one example for your understanding. So let's say that there is the example, let's take the best example, okay, of Reliance Industries. So which is a very well known company in India, Reliance Industry. Tell me, this is a public or private? It is limited. It is a public company, okay, which is having a subsidiary, or that is Jio. We all must be knowing. For your kind information, there are various companies in the name of Jio. Okay, when you go in the subsidiary list of the Reliance, you will find that there are various companies under Jio. But मान के चलते एक company है Jio Private Limited. Okay. Now in this company, as per these two criteria, so let's first talk about the first criteria. Okay. So if it controls the composition, मान के चलते हैं कि Jio में 5 board of directors appoint कर सकते हैं. कितने बोर्ड ऑफ डायरेक्टर्स? 5. और 5 बोर्ड ऑफ डायरेक्टर्स में से रिलायंस कैन अपॉइंट 3 बोर्ड ऑफ डायरेक्टर्स इन द जियो. सो दिस वुड बी माय फर्स्ट क्राइटेरिया. ओके, एंड सेकंड क्राइटेरिया इज व्हाट? कंट्रोल्स मोर देन 1/2 ऑफ द कैपिटल. मान के चलते हैं इफ रिलायंस इंडस्ट्री इज होल्डिंग 60% of the shares in Jio. Now you must be aware, okay, recently the Facebook has purchased 9.99% in the Jio. Okay, then other entities are also coming up, but still the majority of the holding is with whom? Okay, this is my second criteria. Let me put the majority is holding, okay, is with Reliance Industries Limited. So in such a case, okay, who can take the decision? Who can take all the decisions of the Jio? It is Reliance Industries Limited. Okay, and that is the reason, okay, it is called as subsidiary company. Jio will be called as subsidiary and Reliance will be called as holding company. Okay, so let me put that, okay, which can be subsidiary and holding. So Reliance will be called as holding company and Jio will be called as subsidiary company. I hope this is very clear to all of you. Okay, this example is very clear. which is defined under section 2 subsection 87. So section 2 subsection 46 is very easy. Holding company relation to one or more company, okay, means a company of which such companies are subsidiary. So in order to understand this, you need to understand subsidiary company very well. Let's go back. So we have completed these 2 points as well. Let's talk about associate company. Associate company is defined under section 2 subsection 26. Okay, associate is a very easy, you can say, it's a very easy concept to understand. Associate company means a company which is where is the substantial influence is there of any other company. Okay, so in order to understand the associate company, I can give you one example. Okay, let's say a corporation, okay, which is US company, is investing or having some joint venture, okay, or is creating some joint venture with Wheel Private Limited, which is Indian company. So they are coming together and they are incorporating X Private Limited in India. Okay, that is a joint venture. Joint venture is called a JV. Okay, so for some technical collaboration they are coming in India. So this will be my Indian company. So now what will happen? A Limited and B Limited will have some, A corporation and B corporation will have some kind of, okay, shareholding in this X Private Limited. तो मान के चलते हैं A is coming up with 26% of the shares and B is coming up with 74% of the shares. Okay. So in case of the associate company, if there is more than 20% of the shares held by any other company, then it will become the associate company. So in my case, A corporation can become associate company. Yes, definitely it can become associate company when there will be a kind of substantial influence, and that is the 20% or more. Then it will become the associate company. So this concept is basically applicable in joint ventures. And the last point, okay, that is company for charitable purposes. So the name itself says that this is company which is for charitable and not for business purpose. There is one more section given, one separate section is given, that is section 8. Always remember this. This is also called as section 8 companies. In the old syllabus 1956, okay, there was a provision for corresponding provision under the old act, that was section 25 company. So please don't refer to the section 25 company. Now it is called as section 8 company. What is meant by section 8 company? Okay, section 8 says that if it is proved to the satisfaction of the central government that a person or an association of person proposed to register a limited company has an objects the promotion of commerce, तो क्या क्या रहना चाहिए इसमें? Okay, क्या क्या जरूरी हो सकता है? एक तो इसमें ऑब्जेक्ट्स रहने चाहिए, objects to promote art, science, okay, or you can say sports or education, etc. Okay, so in the satisfaction of the central government, you have to, okay, prove that, okay, these are the objects of this company. Intends to apply its profit, okay, or other income in promoting the objects. Intends to apply profits in promoting objects. Okay, intends to apply profit in promoting objects, and intends to prohibit the payment of any dividend. Intends to prohibit the payment of any dividend. ओके देखो ये 3 पॉइंट बहुत इंपॉर्टेंट है. एक तो सेंट्रल गवर्नमेंट को लगना चाहिए कि दिस कंपनी इज देयर टू प्रमोट certain activities which are not business activities. So if anybody would like to start a company for the charitable purpose, it is the best option: art, science, sports or education. जो भी प्रॉफिट होगा, whatever profit it will earn, it will just be applicable or applied in promoting these objects. And the third, it prohibits to the payment of any kind of dividend. So profit cannot be shared, in case of such company, to the shareholders. Such company can be converted into any other form of entity like private company. There are some provisions about it. If such company wants to alter, but in that particular case, your central government approval will be required, because if you have started a company with a charitable purpose, suddenly you cannot go in the business activities, and that is the reason such type of restrictions have been laid down under Section 8 companies. So popularly, this company is known as Section 8 companies. And here we have completed all 15 types of companies. I hope you understood all these provisions very well. Just make a note of this all points very quickly. So we have covered chartered company, statutory company. I have given you examples over here only. Government company, again I have explained here only. Limited by shares, limited by guarantee, and company, which we have covered in the separate slide. Let's move on. Then private limited, public limited, again I have covered in the separate slides. Small company I have defined here only, where the two criteria are there: paid up capital and turnover, which is less. One person company I have defined in separate slide. Foreign company, I have defined here only, which is incorporated outside India but doing business activity in India. Holding and subsidiary I have completed in separate slide. Associate company I have defined over here only, which will be having a substantial influence of more than 20%. And just now we have completed charitable purpose companies, Section 8 companies. So companies on the basis of liability, limited by shares, limited by guarantee, we have covered over here. That is limited by shares, limited by guarantee, and unlimited company. Private limited company, which restricts the right to transfer the shares, maximum members 200, and prohibits invitation to public. Public limited company, which is not a private limited company. So to understand public limited, you better need to understand private limited company. There is one more restriction, like if it is a subsidiary, the private limited, it will be considered as a public limited, deemed to be considered, but on paper it will be private limited only. OPC, we have given some pointers. Only one member should be there. Nominee is required. His consent is required. He should be a natural person. Means the member should be a natural person. Member and nominee should not be a minor. Such company can't be converted into Section 8 company, and it cannot do some kind of non-banking finance investment. And last, we have completed holding and subsidiary companies. By giving example of the Reliance Industries, I have explained this particular point. So it can control what is subsidiary, which is being controlled by the holding company in case of board of directors composition, and which is being controlled by the holding company in case of 1/2 of the total share capital. I hope you have understood the types of companies very well. Okay, there are various types of companies we have studied. Okay, please do watch this video, read the notes, okay, carefully, and okay, get all these concepts clarified. Thank you so much for attending this particular session.